So here's the big news. The federal statute that bars nonviolent felons from owning firearms has once again been struck down as unconstitutional, following an 8-1 ruling from the Supreme Court and a grant, vacate, and remand GVR order in the case. Now, the Attorney General's office has officially chosen not to fight this pro-Second Amendment ruling. They've opted not to take it back to the Supreme Court, meaning they're allowing the lower court's decision to stand as is. This is a massive shift that's worth diving into. As I mentioned earlier, today's video is focused on one of the most important Second Amendment legal battles in recent memory: the right of nonviolent felons to legally possess and own firearms. The Trump administration, along with the Attorney General's office, has decided not to challenge the outcome of Range versus Garland, a landmark case decided by the Third Circuit panel. Rather than push it further, they're leaving that decision untouched. And because of that, the ruling that the federal law banning firearm ownership by nonviolent felons is unconstitutional, at least as applied to Mr. Range, will stand. This is a serious victory for gun rights. It means that more people in similar situations now have a real pathway to take legal action and potentially get their firearms rights restored, just like Mr. Range did. On top of that, the administration recently introduced a proposed rule that would open up gun rights restoration for disqualified individuals, something that hasn't been seen since back in 1992. The Range decision, combined with this proposed policy change, is going to reshape the Second Amendment debate when it comes to restoring firearm rights. Now, in case you're not familiar with the background, the Range case centers around a man who effectively lost his Second Amendment rights under federal law for life. Over 26 years ago, Brian Range was convicted of misreporting part of his income in order to receive extra food stamps for his family. Essentially, he made a false declaration on a federal form to get assistance. That landed him a conviction for a first-degree misdemeanor. But since the potential sentence exceeded 1 year, he was legally barred from ever owning or possessing a firearm again. Because of this, he filed a lawsuit against the federal government to regain his Second Amendment rights. The case eventually reached the Third Circuit. There, a 3-judge panel initially ruled that only law-abiding, responsible citizens are covered by the Second Amendment, and they concluded that Mr. Range did not fall into that category. In short, they said he wasn't one of the people the Constitution protects when it comes to gun ownership. But then the full court, the en banc panel of the Third Circuit, took a second look and ultimately found that Section 922, subsection G1, as applied to Brian Range, was unconstitutional. That led the Biden administration at the time to ask the Supreme Court to overturn that ruling. However, following the Rahimi decision, which came in with an 8-1 vote, the Range case was officially granted, vacated, and remanded back down to the original Third Circuit panel for reconsideration. After taking another look, the same panel reaffirmed their original stance. They agreed with Mr. Range that even though he was convicted of a non-violent false statement, he still counts among the group of people whose rights are protected under the Second Amendment. And because the federal government failed to prove that our historical and traditional framework of gun laws supports disarming someone like Range, the court reversed the decision and sent it back down. In their written opinion, the judges strongly rejected the idea that lawmakers should get to decide who qualifies as the people. They warned that giving Congress unchecked power to exclude individuals from Second Amendment protections, simply by labeling them as felons, would be dangerous and could be abused. They pointed out that such deference directly contradicts the logic set forth in District of Columbia versus Heller, which clarified that constitutional rights are off limits to political manipulation. So in summary, The court threw out the government's claim that felons are automatically excluded from Second Amendment protections, and they did so with strong language that reinforces the idea that fundamental rights don't disappear because of a label. That ruling from the Third Circuit panel was handed down back in December. As I've said before, the federal government, under the Biden administration at that time, chose to bring the case to the Supreme Court. But after the administration change, it ended up in the hands of Pam Bondi, and it became her call on whether or not to pursue it further. The new administration requested more time, and that deadline was extended to April 22nd. That gave them until then to make a decision on whether they would formally bring the case before the High Court. Well, that date came and went, and no petition was filed. So, what does that likely mean? In my view, the Attorney General's office, possibly guided by advice from the newly formed Second Amendment Task Force, chose to drop the case entirely. It looks like they just walked away from it, effectively accepting the Third Circuit's ruling as standing precedent. I also believe that the Department of Justice's recent interim rule on restoring gun rights played a major role in that decision. This new DOJ rule eliminates the delegation of authority that once allowed the Bureau of Alcohol, Tobacco, Firearms, and Explosives to handle applications for firearm rights restoration at the federal level. In the published notice, the Department of Justice explained that this change was meant to clean up outdated rules and is part of a broader firearms policy overhaul tied to a Trump-era executive order focused on protecting Second Amendment freedoms. With this interim rule now in place, individuals who are not considered a threat to public safety will once again be able to petition to have their rights restored under the federal statute. Since the early 1990s, Congress has blocked the Bureau of Alcohol, Tobacco, Firearms, and Explosives from using any funding to process restoration applications, which effectively shut down that process altogether. But this new policy reopens the door and gives people a path forward. Under the current version of the rule, the Bureau of Alcohol, Tobacco, Firearms, and Explosives is officially out of the picture when it comes to processing these petitions. The Department of Justice itself will now take over and carry out the statute. And one key thing to keep in mind, this rule took effect almost immediately. While there will still be a public comment period before it becomes permanent, the new process is already active, and some individuals have already begun the application steps. Putting all of this together, what we're seeing is a major shift from both the Department of Justice and the Attorney General's office when it comes to nonviolent felons and their rights to legally purchase, possess, and carry firearms. They've essentially chosen not to fight the range case, allowing the Third Circuit's panel ruling to remain in place. That decision, plus the new rule providing a pathway to rights restoration, marks a clear change in how these issues are being handled. Now, just to clarify, the range case was what's called an as-applied challenge. So, for the moment, the ruling technically only applies to Mr. Range himself. However, since it now stands as a binding decision within the Third Circuit, others in that jurisdiction can bring similar challenges using Range as precedent. We've already seen courts in other parts of the country citing the Range ruling as persuasive authority, especially now that the Department of Justice is not disputing it. That creates a real opportunity for individuals in other regions to file their own as-applied challenges to regain their rights. And now, with the Department of Justice offering a brand new administrative route to restoration, we've got more than one path forward for lawful individuals to recover their Second Amendment freedoms. Overall, this is really encouraging news from the administration. It seems like the Second Amendment Task Force is actively working to resolve some of these long-standing legal conflicts, We'll keep watching for any surprises. Maybe there's some behind-the-scenes effort to quietly file later or ask for another deadline extension, but I doubt it. As of now, there's nothing on the docket from yesterday or today that points to that. If anything changes, I'll be sure to keep you all updated. If you found this information helpful and want to support the channel, the best way to do that is by hitting the like button, leaving a comment, and subscribing. That engagement really helps push the message out through the algorithm and shows YouTube there's value in covering this type of Second Amendment content. As always, thank you for tuning in, and remember, this nation was founded by scholars, and it will be preserved by armed scholars.